Hello and welcome to The Truth About Wealth with John and Michael Parise of Beech Financial Group. I'm Wendy McConnell. Hello, fellas.
Hello, Wendy.
Hey, Wendy.
It's good to see you. It's always good to see you.
Good to see you.
Yes, likewise. Been a little while, I feel like, but
It's been a while, but summer is kind of, coming to a close. Things are going to get back to normal, all of that kind of stuff, right?
yeah, well, everything's normal with us, just busy, So that's all. That's the new normal.
I've been at the beach, Wendy. So
I was going to say
that's not true. I just got back from Montana, so that's not true.
So, what are we going to be focusing on today, guys?
Today's going to be an interesting topic, one that I feel like we've touched on a few times through the years in various forms. This term we use to talk about is called asset succession, and it's really more of an estate planning topic, but it's going to be more focused on things like your beneficiary designations. It's often, we find, an overlooked, I don't want to say forgotten about topic, but when we go through the estate planning process, a lot of the time the clients are really jumping into looking at various trust forms or sort of advanced planning, and usually their beneficiary designations are one of the most important things that they should be looking at right from the get-go before they jump into that, because there are specific circumstances on various assets that can lead to different outcomes for an estate plan than just for in a normal trust or will context. So that's what we wanted to talk about today, is just more almost refocusing some clients or listeners out there with this type of topic, and just almost like remember how this should be handled in your estate plan today.
We always get questions from our clients that they forget what their beneficiary designations were in their structure. So we kind of remind them you have to look at that and remind yourself that you have to check that every once in a while. And we have some cases where, we'll chat about a case study a little bit, maybe, that we ran into a family on the West Coast that dad had a second marriage and all his IRAs are going to his kids. No. That doesn't work real well. So we can talk about that in a minute. Mike?
Yeah, I think that the first thing to think about is to remember that certain assets do not flow through your will. And those are typically assets that have a beneficiary designation attached to them. Things like your 401k plans, your IRAs, a life insurance policy. Those assets go by whoever your beneficiary is. And so very often you might actually be in a situation where you have a lot of your wealth or your assets that are with those types of assets and accounts, and you might have a will that says something totally different than what your beneficiary designations actually call for. So it's really important to just take stock of that. It doesn't necessarily mean that you need to make any changes there, but just recognize that those types of assets and those accounts are going to flow in your estate plan, if you were to pass away, by your beneficiary designation that you've attached there, not through your will. So that oftentimes comes up. We have a lot of families where they have, sometimes more than 50% of their net worth are in, let's say, an IRA. They've been very successful. A lot of physicians, this is the case, where they've contributed a lot to retirement plans throughout their career, and they've built up a lot of assets and a lot of their net worth in those types of accounts. And that's really where 50% of their assets are going to go if they were to pass away. So it just might be different. So again, it's not necessarily to imply that you should make any changes there. It's just to keep that in mind. The other asset are assets that are jointly titled. So we talk about this a lot as a way to avoid probate. If you have a jointly titled asset, like a jointly titled bank account, or your personal residence oftentimes is in the name of spouses, those assets will inherit via that joint title. So if one of the owners passes away, typically the other owner inherits those assets. We call it by operation of law. So you might have in your will, I leave my house to my children, but if it's jointly titled with a spouse, your spouse is going to inherit that upon your passing. So it's one of those just kind of flowing just look at where the assets are going to go based on how they're set up and structured.
Yeah, when you look at the estate piece, there's always a discussion we have with that joint title asset, the step-up provisions under the law, under the tax code, when one passes away, what happens from the tax standpoint. Mike, you want to kind of review that? It's always
Yeah,
interesting conversation.
the stepped up income tax basis is an interesting tax provision that basically says if you own an asset upon your passing, your tax basis in that asset steps up to the date of death value of that asset. So the most common example that I give is you buy a stock at $1 a share, and when you pass away, that stock is worth $5 a share. If we were to sell that stock during your lifetime, you would have a $4 capital gain that you would pay tax on if you sold it during your lifetime because you bought it for $1, it's now at $5. If you pass away owning that asset, the basis, your dollar purchase price, steps up to the $5 value, which means that your heirs can sell that asset without paying any capital gain tax on that transaction. So that's been in the tax code for a long time. There are rumblings that the Democrats in particular might want to change that provision for various reasons. Right now, it still is in the law. You can take advantage of that, but that's how that tax provision works.
Yeah, it's always good to look at, as Michael pointed out earlier, the structure of all your assets. And some of the clients we work with are very, very complex. They have business assets, real estate assets. They have assets held in trusts. They have assets owned by kids. I mean, it's really you have to take a step back and say, where's all this stuff going? Now, we often talk about asset protection as a theme in our modeling. A lot of the clients are concerned about exposure of that wealth that they created through the years, and they want to protect it. So again, getting back to that beneficiary structure and look at where things are going is a very, very important step. Now, on the IRA side, we talked about this in the past, there's something called the Secure Act that just changed the way IRAs are inherited by kids. There used to be a stretch rule, if you remember the old laws prior to 2020. When mom and dad passed away, IRAs transferred to the kids. They were able to stretch that IRA through their lifetime. Oh, that is now gone. So they have to be paid out of that IRA over a 10-year period of time. So that old asset protection story now changes. Now assets are exposed to the kids and their estates. And to Michael's point, we have a lot of physicians that have multi-million dollars in these accounts that are now going out to the kids with no asset protection. So it's an interesting discussion to have, and you really have to start paying attention to it, especially in today's world. Things are moving way too quickly for a lot of people.
Yeah, IRA accounts are very peculiar assets if you think about it from an asset succession standpoint. For that reason, there's a lot of very complicated tax laws surrounding how those assets pass down generationally, and you alluded to the Secure Act. That's even complicated, I think, even further. And oftentimes families, what they have to really consider is almost a trade-off between the income tax benefits, or what strategy will maximize income tax planning versus what strategy might maximize asset protection. Because a lot of times you incorporate trusts in your estate plan and your generational wealth plan for asset protection purposes, but that might not be the best tax story for IRA accounts in particular. So take a spouse as an example. There's a law under the IRA rules that allows a spouse to inherit another spouse's IRA and essentially make it their own. So if you're a younger couple and God forbid you have one spouse that passes away, the surviving spouse can essentially make that IRA their own, and they can continue to defer the tax implications of that IRA because it can continue to grow tax-free, and they can keep that in a tax-favored position until their retirement years. That's different than if a child inherits it. But the downside of that is now the only way that you can accomplish that is by having the spouse take ownership of that in his or her own name, which means if there's a subsequent remarriage or creditor issue, depending on the state that you're in, there might be additional exposures there. So you really have to just balance those two issues. There's no right or wrong answer there. Every client, I think, is going to be a little bit different in how they look at that. But that's just something to keep in mind. That's why we wanted to really talk about this, because remarriage in particular is, you mentioned that case that we dealt with quite a few years ago. That's an area where you just have to be careful with how that is all structured. If you get remarried and you've inherited a retirement account from a deceased spouse, you might want to have conversations with your attorney about maybe a prenuptial agreement to help protect that asset, assuming you want to keep that within the bloodline of let's say the first family, and children from that line. So there's a lot of things that you just have to keep in mind. And again, all of this really, in a way, bypasses your trusts. So that's just an area that you want to keep in mind if you have significant assets in qualified plans, we call them IRAs, 401k plans, pension plans, things like that.
Yeah, and under the rules, and this client was in California, Michael could walk you through the state regs around sharing assets among spouses. And the problem happened with this where dad wanted to leave his kids the IRAs, and it would have violated all the rules in the state. It would have been a major, major problem between the kids and the second spouse. It was a challenge to unravel it, but we accomplished that.
Yeah, it could have been a lot to do with community property laws in California. As an example, a lot of states in the country are under community property, which is the presumption in those states is that property is owned jointly by both spouses. So in that case, this was an account that was opened prior to the second marriage, but it was funded during the second marriage. It got a little bit convoluted in terms of how that asset would be treated upon the owner's death. And so again, it's going to vary based on the state that you live in. It's why you have to really keep in close contact with your advisors, your tax advisors, your legal advisors, just to make sure that that issue gets dealt with, because in this client's case, it actually resolved itself just fine, but it could have been an issue if it was not dealt with properly. So yeah, it's very important.
And also, when you look at life insurance beneficiaries, that's also we see that quite often where dad took out life insurance policy years ago. His first wife was the beneficiary, and he remarried and never changed the beneficiary designation. So a lot of the data you have to really look at to kind of update and get a review on where all these assets are going to ultimately go, and you want to make sure they get to the spot you want to get them to, whether it's kids or trusts.
Yeah, that's a really good point. Anytime you have, I would say, a major life event, it's probably a good time to look at those beneficiary designations. If you get married, or you have marital separation, or you get remarried, those are the times where you should go back and look at your beneficiary designations just to make sure that they're structured in a way that you would want them to go. I mean, we've seen issues where younger unmarried individuals have opened up an IRA account, and because they didn't have any children and they weren't married, they named their siblings as the beneficiaries of those IRAs. And then they got remarried, they had children, and they've unfortunately passed away. And then their siblings, had some level of entitlement over those assets, depending on state law. And so it's one of those issues where you just want to make sure that when those life events happen, that you're looking through all of that and just making sure that it's what you wish.
I could talk about that case that we're working on now currently, where the brother passed away and the IRA was to his other brother. Mm-hmm. And you want to talk about that case?
Yeah, that was a kind of a similar story where the IRA was he had a child from a first marriage. He wanted to make sure that his child was a minor at the time, and he wanted to make sure that his brother was the beneficiary of that IRA, with the assumption that his brother would be able to manage those assets on behalf of his child. Now, there are other ways, better ways to accomplish that objective, we think, but this was before we met this particular client. So that was how it was structured. We got brought in after the fact. And it's caused a little bit of an issue because he has since passed away, and we believe the intent was that he wanted these assets to go to his child. He just didn't structure it that way. And so now to try to unravel that, there's gifting issues that you need to account for. There's income tax exposures that you need to manage. So it's again, if you get anything out of this podcast, it's just to try to pay attention to these issues, go back to your advisors and talk to them, and just ask questions, and you'll get the right answers, hopefully.
Yeah, his heart was in the right spot, no doubt about it. I mean, he wanted to make sure his son was taken care of. But again, the devil's in the details. You don't look at that structure, it could wreak havoc on the family's relationships going forward, and tax issues, as Michael's pointed, and just have it exposed to bad things. That's all.
Yeah. A lot of times in a business owner context too, this could be something that crops up. We've talked a lot about on this podcast doing advanced planning. You can transfer business interests out of your estate into an irrevocable trust. But very often how that's structured is you want to transfer non-voting shares because the owner of the interest wants to maintain control and management over that business by retaining the voting interests. Well, if they retain the voting interests in their name, though, that piece of it will flow through their will and their estate plan if they have ownership of that at their death, absent some other like a buy-sell agreement if there are multiple partners. So again, now you have different paths in which the business ownership and shares might be traveling down via different trust vehicles. So it's really important that somebody on your advisory team is really looking over this and providing almost like an organizational map of sort of here's how these assets will flow, because you might have transferred the non-voting interests into a trust, and that trust might say one thing, but your voting shares might say or might go in a completely different direction because of how your will and your estate plan is structured. So a lot of these trusts have to interact with each other, and it can get complicated depending on the family circumstances. So again, try to have some oversight over this. Try to think about these issues if you can, and talk to your advisors about them.
Yeah, how I think about things through my lifetime is I always try to have the end game in mind. If I buy an asset, if I put money someplace, or I buy a business, whatever it might be, what's the end game? What's going to happen to that enterprise if I passed away, or if I wanted to sell it someday, or if I wanted to give it to my kids, or if I want to put it in trust? What's my end game? So you start kind of backwards. So if you think that way, you start thinking through the opportunities you have to protect those assets from going in a wrong direction.
Mm-hmm. Yeah, I think it's important to just, again, take stock in the differences between maybe the income tax issues and the asset protection issues. Again, getting back to the IRA accounts, retirement accounts in general, a lot of individuals would like to incorporate more asset protection for their children, and they've left all of their other non-IRA assets in trust for their kids, but they leave their IRA outright to their children. Well, that might be a better tax story for the children, even though the Secure Act has made that less attractive. It's still, because of the laws as they exist now, a better tax story, but you're giving up the asset protection benefits from that oftentimes. So it's that trade-off. So
balance.
Yeah, just look at your asset base and think about those sorts of issues if you can.
And folks, with Roth IRAs, the laws are the same around Roths. You have a 10-year window, you have to give that out to the kids. So it's just not a regular IRA, or Roth is under that law as well.
The tax story is better with that, right? Because
absolutely, everybody should have a Roth.
Yeah, if you can, yeah. But to your point, the asset protection piece of it, those assets generally are left to individuals. There might be ways that you can leave it to trust for your children, but again, just check in on that.
Yeah. So the message here is sit back, look at your assets, and some families have a lot of assets and they're complex, and especially with the laws changing. I think there's a sunset next year on some of the tax codes. There's a lot of different stress points on what am I going to do now with these assets, and what's the tax exposure, and how do I put them in the right bucket? So it's time to review. If you haven't reviewed it, and you should do it every year. I don't know. We always advise our families to meet it with us quarterly. I mean, they hate that. Unfortunately, we force them to do that because it's the right decision. Because you don't pay attention and you don't stay on top of it, things fall through the cracks. I mean, we talk to people all the time, and they say, I wish I would have done that, or I should have done that, or I could have done that. I didn't know. It's an educational process as well, Wendy. So it's really be informed, and hopefully you make the right decisions along the way.
I'm with your family. Like, I don't want to do any of this stuff. I'm not good at this stuff. I don't understand this stuff. I don't know. So I need people like you to be like, Wendy, it's time to check on those beneficiaries, just to remind me to make these decisions. But good for you guys for making the family come in and figuring all this stuff out.
Oh, they hate us. Yeah, you have to meet again. We put heat on it because I think it's the right way to do it. And we care about our families. We care about their kids, and how they structure things has an impact, negatively and or positively. We want to make it always positive if we can. That's the strategy. I mean, listen, no one likes finance. I begin after 38 years, almost 39 years in this business, people are still struggling with understanding the complex world of finance. We don't teach it in school. We could have that conversation for another day, but no one's educated from high school to college, and you'd think that would be a great course. I know a lot of universities now are teaching, financial planning more so, but when I was growing up, it was unheard of. So get up to speed. And if there's courses you could take, take some courses and learn about all the different financial structures that you should be looking at, whether it's trusts or beneficiary designations, ownership of assets, LLCs, C corporations, S corporations. These are all very complex pieces of the pie that you have to pay attention to.
Yep.
No, I don't want to do it.
No one wants to do it, Wendy. Everyone hates to do this.
Is
They
it
get
true? Does
frustrated
everyone
with it.
hate it? Because I mean, it seems so much more complicated than it has to be.
My wife says, something happens to you, John, I'm calling Michael. She doesn't want to know anything. She's way beyond me. She's a speech therapist by trade. She hates finance, hates, writing checks. She just doesn't like money at that level to pay attention to it. So she relies on me to do it, which is fine. But if I go, he's the guy. But she wants nothing to do with it. So there are a lot of people like that. Unfortunately, it might get you in trouble if you have that kind of a attitude about it.
Yeah, and everything is custom for every family because every family's circumstances are different, and so what works for one family might not work for another family, and the laws are changing all the time. I mean, going back to the Secure Act, we've talked a lot about that law on this podcast. I think for good reason, because it really has changed that IRA world, that qualified plan world, a lot, and that's not, I don't think, going to change. I think there's going to continue to be law changes, whether it's on the tax side or state laws that are going to change and adjust. There are certain states now where we talked about that beneficiary designation earlier, where if you do get divorced from a spouse and you forget to, let's say, rename your children or your subsequent spouse, where there's an automatic essentially change that the states have put in place to protect that, because the presumption is, well, if I got divorced, I didn't want to have my ex-spouse to be the beneficiary of that. Or, oftentimes that's dealt with in the divorce decree that, you go through, but sometimes things get overlooked. If you forget that there's an account, over here and never got talked about, that stuff happens all the time. So there are ways in which states are trying to protect, I think, account owners from that, but that's not in every state, and those laws are going to change all the time. So it's important that, again, you just pay attention to it if you can.
It's hard. It's really, I don't envy anybody who doesn't really focus on their financial affairs. It's hard to do it right, and it's easy to do it wrong because they don't pay attention to the bouncing ball, and you have to. I know we talk about that stuff all the time. I apologize if I get annoyed about it, because it's a weakness that we see in the marketplace. People just not paying attention, and they assume things are right, and all of a sudden someone passes away or someone becomes disabled or some bad event happens to a family. And, well, I didn't know that was going to happen. Now what? And now it's too late to make those changes. So it's really good to take a peek under the hood, as I like to say.
Mm-hmm.
Yep. Tune-up. It's time for a tune-up.
That's a good phrase. That's a real good phrase.
I don't think I have any more thoughts that we haven't already covered today. Trying to think of any other topics that
I think we covered. I think we hit them a bit.
I think everybody got the point. I mean, there's obviously a lot more that goes into this conversation, but I think as a sort of a primer, or as tweak your thoughts, I hope that this was helpful for everybody that's listening. And if you'd like to get in contact with us, you can reach out to us on LinkedIn, social media. You can call us, phone number 856-988-8300, or you can reach us on our website, www.cbfgllc.com. And happy to talk to you, and hopefully we can help you.
All right. Always great to see you guys. We'll see you again soon. So thank you for listening today. Please like, follow, and share this podcast with your friends. Until next time, I'm Wendy McConnell.
Thank you for listening to the Truth About Wealth podcast. Click the subscribe button below to be notified when new episodes become available. The information covered and posted represents the views and opinions of the guest and does not necessarily represent the views or opinions of Copper Beech Financial Group. The content has been made available for informational and educational purposes only. The content is not intended to be a substitute for professional investing advice. Always seek the advice of your financial advisor or other qualified financial service provider with any questions you may have regarding your investment planning.
This material is for informational purposes only. Neither APFS nor its representatives provide tax, legal, or accounting advice. Please consult your own tax, legal, or accounting professional before making any decisions. Copper Beech is not affiliated with American Portfolios Financial Services, Inc. and American Portfolios Advisors, Inc. Securities offered through American Portfolio Financial Services, Inc., a member of FINRA SIPC, investment advisory and financial planning services offered through American Portfolio Advisors, Inc., an SCC registered investment advisor. These opinions are subject to change at any time without notice. Any comments or postings are provided for informational purposes only and do not constitute an offer or a recommendation to buy or sell securities or other financial instruments. Readers should conduct their own review and exercise judgment prior to investing. Investments are not guaranteed, involve risk, and may result in a loss of principal. Past performance does not guarantee future results. Investments are not suitable for all types of investors. Copper Beech is an unaffiliated entity of American Portfolios Financial Services, Inc. and American Portfolios Advisors, Inc. Any opinion expressed in this forum is not the opinions of American Portfolio Financial Services, Inc. and American Portfolio Advisors, Inc., and have not been reviewed by the firm for completeness or accuracy. American Portfolios and Copper Beech Financial Group are not affiliated with any other named business entities mentioned.